If you ever want to know why Second Amendment supporters should be sending money and support to those groups that fight for our Second Amendment rights, this story here about the bumpstock case illustrates the point dramatically. Specifically, this case we're about to cover is a case where the gun owners of America asked for $400,000 to reimburse them for their costs and attorney's fees for fighting all the way to the U.S. Supreme Court on behalf of Second Amendment supporters in the bumpstock battle. And guess what a federal judge awarded to them? About $700. Let's break down what just happened here in Michigan when we come right back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the 2025 top voice of the Second Amendment, according to the 2025 Gun News Awards. Thank you all for your support. You all made that happen, and I really do appreciate it, and I hope to continue to earn your respect and support moving forward. All right, folks, so crazy here. Gun Owners of America, as you know, brought a lawsuit in the federal court in Michigan several years ago, arguing that the bumpstock ban by the ATF after the Mandalay Bay Las Vegas shooting, after that all occurred, brought a lawsuit claiming that the ATF's bumpstock ban that was done by executive order, not through legislation, which strategically was good for us, by the way, but set that issue aside. So Gun Owners of America brought this lawsuit many years ago, fought it all the way up to the U.S. Supreme Court with other gun rights groups, and ultimately prevailed, expanding freedom, shutting down the ATF, locking down and eliminating this so-called federal bumpstock ban. Great news. So in light of this major win, using private money, either presumably from their bank accounts or from donations or however the Gun Owner of America raises their money, presumably mostly donations from people like you and me and others, guess what? They spent a lot of money. Actually, they didn't spend a lot of money compared to legal bills I've seen in my career. They spent a reasonable amount of money, $400,000 in attorney's fees and costs, meaning what you had to spend out of pocket. And they brought a request in front of this federal district court judge using the Equal Access to Justice Act, a federal law that said that if you prevail against the federal government in cases like this case here of Gun Owners of America versus Merrick Garland, dealing with the bumpstock ban, you're entitled to your attorney's fees. But there's an exception to that rule, and that exception is essentially that if the government's position was reasonably supported and was a reasonable position, substantially justified, if you will, then the government doesn't have to really pay a dime. So as part of this, and we've covered this before in prior videos, the Gun Owners of America asked for somewhere in the order of magnitude of $400,000 in attorney's fees, plus $35,000 in costs, which is the amount of money they paid out of pocket for legal research, probably electronic research, filing fees, copies, whatever. Okay? And they asked for the $435 some odd thousand from the federal government to be paid in light of their work fighting for America. Now, I should make one note. Listen carefully. If you prevail in a pure Second Amendment case dealing with civil rights under a federal statute 42 U.S.C. 19, well, actually 42 U.S.C. 1981 through 1988, it's a sort of a group of them, you're entitled to your attorney's fees, reasonable attorney's fees under a particular statute, 42 U.S.C. 1988. But that assumes that you sued, listen carefully, state and local governments, state and local actors. Those laws I just described, 42 U.S.C. 1981 through 1988, for the purposes of the Second Amendment at least, don't allow you to recover attorney's fees or anything like that from the federal government, just from state and local governments. Now here in Gun Owners of America versus Merrick Garland, this is not technically a Second Amendment case. It had an impact on the Second Amendment, very important for the Second Amendment. But it was really a statutory interpretation case and a fight about whether or not the ATF was behaving properly. And of course, we know that the U.S. Supreme Court ultimately said the ATF had got it all wrong. That bump stocks could not be banned could not be banned by the wave of a magic wand by the president or the ATF or anyone in the executive branch, despite what Joe Biden and his attorneys argued all the way up to the U.S. Supreme Court. Nevertheless, the ATF refused to pay gun owners of America the over $400,000 they sought on the grounds that the ATF and the government's position was substantially justified. So, just to give you a sense of what the judge said about this argument and where it came out, this is how the judge starts his opinion out there in federal court in Michigan with respect to the request by gun owners of America. After the Bureau of Alcohol, Tobacco, Firearms, and Explosives, the ATF, adopted a final rule reinterpreting the definition of machine gun and banning the ownership of bump stocks, plaintiffs, gun owners of America, filed this lawsuit. In other lawsuits, the United States Supreme Court and the Sixth Circuit Court of Appeals issued rulings favorable to these plaintiffs. Binding on this court, those opinions provided the basis for resolving this lawsuit on the merits. This court has since issued a final order. The plaintiffs, gun owners of America, now seek attorney's fees under the Equal Access to Justice Act. Plaintiffs seek over $400,000 in attorney's fees and approximately $35,000 in litigation costs. In response, the government defendants contend that the government's opposition to the lawsuit advanced a substantially justified position, one that would satisfy a reasonable person. So that's kind of how it's framed up. But again, the thing to keep in mind is sort of the unfairness of the situation, which is you have the federal government, which literally has a multi-trillion with a T, $trillion with a T budget, hundreds of billions of dollars dumped into the Department of Justice for all sorts of reasons, many of which are nonsense, but that's a separate issue, up against a relatively small, in the grand scheme of things, group of Robin Hood-style lawyers who are excellent and very serious and earnest and very capable and competent with impressive credentials and impressive results all across the board. But when you compare the size of the gun owners of America, no matter how you measure the number of employees, number of lawyers, budget, doesn't matter. They are a teeny little tugboat in the great Pacific Ocean of the federal government, right? The federal government is this monstrosity, monster with infinite resources, and I mean infinite. Because any money the federal government doesn't have, they can literally go out and print it up, which is what causes inflation. But we're not going to talk about monetary policy on this video. But you get the point. Totally unfair in terms of size advantage versus size disadvantage, of course. Nevertheless, here you have a very modest request for attorney's fees being absolutely denied by the Joe Biden Department of Justice and then, of course, blessed by a federal judge. So here's what the judge said and continued on in rejecting the request by gun owners of America for this very reasonable attorney's fees, given the accomplishments that arose from the expenditure of this money. The federal government has established that its position in this litigation had substantial justification. Congress had not defined the key phrases that underlie this particular dispute. At the time the ATF promulgated the final rule, the proper interpretation of the word machine gun remained unsettled as to its application to bump stocks. The federal government's interpretation of single function of the trigger and automatically had some basis in earlier court opinions. The Sixth Circuit Court of Appeals has found that the government's position was viable and reasonable. And prior to its opinion in Cargill, the Supreme Court had denied 4 petitions for cert where the Circuit Court found that the government's position was reasonable. Viewed in this context, the Supreme Court's rejection of the government's interpretation in Cargill does not render the government's position unjustified for the purpose of EAJA fees. A reasonable person would think the government's position had a basis in law and a basis in fact. The gun owners of America plaintiffs have not persuaded this court that ATF's reversal from its earlier conclusion or alleged factual disputes provide a sufficient basis to find the government's position was not substantially justified. Therefore, For the reasons provided in the accompanying opinion here, this court denies, in part, plaintiff's motion for fees and costs under the Equal Access to Justice Act, and the court awards plaintiffs $724 in costs. It is so ordered. Wow. So a request for over $400,000 gives rise to a fee award, which is really just a cost award, of about $700. So if you ever want to understand why it's important to support gun rights organizations, Second Amendment organizations, this case illustrates the point. You see, the federal government, now, by the way, things may be different in Trump land. We don't know yet, but set that issue aside. The reality is that the federal government, in addition to state and local governments, and most federal judges have no interest in finding a way to support the Second Amendment or gun rights. So if there's any debate whatsoever about whether or not a federal judge can find in favor of the government and deny Second Amendment groups the ability to collect money from the federal government, they're going to take it. It's just the way it is. And remember, and listen carefully, the reality is this. Most of these lawsuits, not all, but most of the lawsuits dealing with the gun-related issues, dealing with these Second Amendment-related issues are where? They're in terrible jurisdictions usually. They're in places like New Jersey, New York, California, Illinois, right? They're in terrible jurisdictions as a matter of, because those are where the anti-gun laws arise from, okay? Which means that you're going to be in front of, not always, but often, if not the majority of the time, you're going to be in front of judges who don't like the Second Amendment, who don't like guns, or maybe just don't know about either. All of which, of course, makes it problematic to be able to win those cases. And even if you win those cases, it makes it extra hard to collect money. And here's an example of this. Here's a case where you literally had a victory, a huge win, not in some local county court, not in some family court, not that there's anything wrong with those courts. You literally had a win in the highest court of the land. You had a major win in the United States Supreme Court against the multi-trillion-dollar-a-year budget of the United States government, the Department of Justice, Merrick Garland, not to mention the budgets associated with the anti-gun groups, that many of which submitted briefs in this case. So just think about what the Gun Owners of America was up against here and the other groups that fought for our rights in the Supreme Court and all the way up. Because remember, you can't just go to the Supreme Court. You got to work your way up and create the proper record and make the proper arguments and don't waive the wrong things and don't make any mistakes. If you do any of the above, you trip up in any respect. And when you get to the U.S. Supreme Court, you're going to get knocked out on some procedural problem. So you've got to do everything right, preserve your record, make your arguments, make all the arguments right, make all the facts right, get it into the record, do all that stuff right before you even get to the Supreme Court. And then you got to win in the Supreme Court. It's not easy. It's like winning a Super Bowl. It's a lot of things that can go wrong between training camp, the regular season, the playoffs, getting to the Super Bowl, and actually winning the Super Bowl. And here, the Gun Owners of America and other groups supporting our rights succeeded, and nevertheless, despite a request for $435,000, which I can assure you for a multi-year litigation of this level of complexity is not a big number. I'm just telling you. I know what a big legal fee is. This is not a big legal fee. This is extremely reasonable. I know it sounds big, but remember, it's a pure over many years against a very difficult competitor, a very difficult adversary that has infinite budgets, just the way it is. And basically to be given, an award of $750, well, it's crazy. And again, I'm not saying the federal judge got the law wrong per se, or tried to get the law wrong. It's just the reality of the way these laws are designed to protect big government, to protect the deep state, to protect people that work for the government over us peons who are just ordinary Americans, who are trying to be citizens and not relegated to serfdom and not become subjects. And by the way, I think we're doing pretty well over the last week or two, but we'll talk more about that in the future. So there you have it, kind of an unfortunate set of events involving the Gun Owners of America, but I'm going to give you some good news. here's what I would consider doing. I think it may make sense for someone on behalf of the Second Amendment to start submitting FOIA requests to the Department of Justice, to the ATF for all their files, all their notes, all the information that they dealt with associated with their decision to change their views on that bump stock was not a machine gun to it was a machine gun and should be banned, and to pull all those files and make those FOIA requests, and then someone should pick up the phone and reach out to the Trump administration's lawyers and recommend to them that perhaps any potential privileges that might apply that would keep these documents and in this information from being disclosed to the public, that perhaps the Trump administration should consider waiving those defenses to those federal FOIA requests, pull all this information together, and maybe upon reviewing that information, if you can get it, associated with the bump stock fight, maybe, just maybe, there's some new information and new facts that come to light, which would allow the gun owners of America or these other groups to move to reconsider on the basis of new evidence uncovered to reopen the question of whether or not the government's position in the bump stock fight was substantially justified or was it not. Again, I don't represent anybody here. I'm not telling anybody what to do. I'm just throwing out a suggestion about how I might go about keeping this fight going with a FOIA request and some other requests. In theory, you could even have considered discovery in this, but I guess I would probably not have spent the money given the nature of this fight. Anyway, just some food for thought there. All right, folks, so there you have it for today. Make sure you subscribe both here on YouTube and on Rumble moving forward. I'm trying to grow the basis on both platforms. Don't forget to follow me on X at 4 Boxes Diner, and I look forward to seeing you again very, very soon here at the 4 Boxes Diner.
Orders up. Table 2A.